600 lawyers from across India, including notables like Harish, Salve, and others, have written an open letter to the Chief Justice, Justice Chandrachud, talking about what they call a vested interest that is trying to defame the courts. I'm Barkha, you're with the Mojo story. On the program today, we're taking you inside this dramatic letter, an open letter that has been written to Chief Justice Chandrachud. This letter speaks about vested interests that are trying to take down the dignity of the judiciary. The letter also calls out what it calls a concocted allegation of bench fixing, the suggestion that who hears your case determines the outcome of the case. The letter comes at a time when the Delhi Chief Minister has been arrested, and India has said that it is both unacceptable and unwarranted that countries like the United States of America and the United Nations today have expressed a public comment on what India calls the internal matters of our country. How do we understand this letter? Will it politicize the legal fraternity? Or will it, as the letter says, preserve the dignity of the institution of the courts? Let's introduce our very distinguished panel of lawyers today as we look at this letter written by 600 lawyers to the Chief Justice. Joining me on the program is lawyer Sautik Banerjee. Welcome to the program, Mr. Banerjee. Also joining me is the head of the Supreme Court Bar Association, Dr. Adish Agarwal. Welcome to the program, sir. Also joining me is Senior Advocate Percival Billamoria, and also joining me is Senior Advocate Karuna Nandi. Welcome everybody to the program, and let's get started straight away. We'll be showing you excerpts of what's in the letter. I'll start with you, Mr. Billamoria. Yesterday we were talking about Arvind Kejriwal, and you made a reference to this letter. Do you support the letter? I don't see you as being a signatory to it, but do you in principle support it, and if you do, why?
Well, let me put it this way. I agree with the sentiment expressed in the letter, but I have reservations in, putting this down in writing, and that also in an open letter. See, because primarily we do not want a fractured bar, right? I mean, see, as judges and lawyers, everyone has their own politics. Everyone has their own belief system, right? Now, very often we find we have to present a case, even if we do not personally agree with the issue, or if we are representing a character we personally find distasteful. As lawyers, we have to do our duty. Now, in this case, of course, the narrative has gone to a point where I think certain individuals thought it necessary to correct it. And as I said, I completely agree with the sentiment. But you cannot have an open letter, because what this does is it creates a wrong impression. I mean, see, the judiciary is well capable of looking after itself, and I don't think it's a. I would not have certainly signed that letter, although definitely there is merit and substance in what is said there.
So you agree with the you agree with the principle, but you do not agree with making it public.
Yes, I don't.
But it might have been a private letter that could have leaked anyway.
Look, I mean, okay, so Mr. Kejriwal's so-called appearance in person yesterday, which in my view is clearly grandstanding, right? I mean, he's using the courts as a election platform. Now, I mean, how did that leak into the public? Right. So I think if both sides are going to indulge in this, then I mean, it's really the judiciary, the name of the judiciary, and the reputation of the bar that will suffer.
I think that's an excellent point about the leaked audio tape of Arvind Kejriwal. And let me bring in Dr. Adish Agarwal, and then I'll go to the others. Dr. Agarwal, Percival Billamoria says good principle behind the letter, he thinks. I don't know if the others will agree, but public kyun kiya? Why is it public? Why are we trying to politically fracture the bar? As the Supreme Court Bar Association president, aap kya kahenge?
As a matter of, I have not made it public because I was not the only signatory. Others, about 600 members of the bar, Indian bar, are there. I earlier what I wrote, I make it when it was necessary, but I have not made it public. But press asked my comments, so I given comments. So, but it was not necessary. I fully agree with my colleague that it was not required to make it public. It should have gone to only CGI, and CGI would have come to know of our sentiments.
So you also think the letter should not have been public, but can you talk a little bit more about the sentiment? Why this letter now? Is it because of the Kejriwal case? Because the letter, Dr.
No,
Agarwal
no,
also
no, no. It
it
is
makes a
it
specific
it is
reference. It makes a specific. Sorry, just let me complete my question. It makes a specific reference to political cases, right? The very
yes.
high up in the letter, it speaks about political cases. So the
Yes.
timing looks like it has some connection with the Kejriwal arrest. Does it?
No, no. This is not relating to Mr. Kejriwal. It is relating to the case where Miss Kavita, for whose Mr. Kapil Sibal was appearing before court number 2, and he asked for bail from the Honorable Supreme Court. And Honorable Supreme Court told him clearly that we are not dealing with the bail matters initially. In SLPs, it comes, then it can be decided. But this is not, this is a case of trial court where he should seek bail. So court told, but he told, no, you kindly decide. You even dismiss it, but you decide. Supreme Court judges can't go beyond the rules. They are the Supreme Court judges. But bail matter directly they are not dealing with. So, but then he says, if you are not dealing with this, then you will be, we will be not, your tenure will be not of golden era. That the lawyers, bar leader saying something where we are not a party in any case, that is something else. But a litigant lawyer is giving certificate to the judges.
Hmm.
This we can't tolerate.
Okay, so you've put it at least in very specific framework about Kapil Sibal's public utterances in court, in open court, talking about how the judges should think about the legacy that they're leaving behind, which you think exceeds the remit or the rights of a litigant or her counsel. Karuna, do you see merit in two examples that have been given? One, if Arvind Kejriwal's audio leaks from the court and the Aam Aadmi Party then widely disseminates it, Percival Biramoria says that is an example of the courts being used politically. So that's point one. Point two, to Dr. Adish Agarwal's example of Mr. Sibal arguing in court and asking the judges to reflect on their legacy. He's saying this is politics. How do you respond to both these points and to the letter in general?
Well, first, let's talk about the openness of the letter and the openness of the what Mr. Kejriwal said in court. Now, there is the principle of open justice that where what happens in court should be public. Now, that is something that the Chief Justice has very strongly espoused, and the idea being that it is that strengthens, not only strengthens the faith in the judiciary and opens it up to public engagement and legitimacy, right? The letter is slightly different, it's true, because the letter is not in court, and the letter was written by 600 people. The letter is widely referred to as an open letter. So the letter being made public, I don't think there's any doubt that the letter was at the first instance meant to be public, right? It wasn't just meant to be addressed to one person, even if he's a constitutional authority, the Supreme Court Chief Justice. It was meant to be for everybody. So let's take that as an. Now, if that letter, or given, if I may say, that letter was meant to be public, and it is saying that there will be allegations that the court will be seen as biased if you give in to those vested interests, right? To me, is actually doing two things. One, it is doing what it says others are doing, indirectly, right? It is ignoring the fact that the Chief Justice has himself said that, look, there are things being said on social media and in other places, and the shoulders of the court are broad enough to ignore or deal with such things. Number one. Number two, what is the context? And if you look at what was being said in the context of the electoral bonds case with respect to, or with due respect to Mr. Agarwala, who had, of course, written a letter to the president saying, please get rid of the judgment, although neither the president nor, of course, the president of the Supreme Court bar has jurisdiction to do so. What was being said in court during the SBI hearing was really skirting on contempt. I think that this court has been, this particular constitution of the Supreme Court has been quite restrained in not issuing contempt, and I don't think contempt should be issued in these kinds of cases. Right?
Okay. Okay.
The court was, I think, somewhat outraged by saying, don't shout at me. Now, it had to be said, don't shout at me, right, to a lawyer. And said that I am saying as Chief Justice. I mean, various people just standing up and saying things when they didn't even have an application before. It being said that judgments are being passed behind the back of the policy. Now, that is not how the Constitution envisages the court to be. The Constitution envisages a point, which is that, and the separation of powers is something that is very important here. And when you have the Prime Minister espousing this 600-person letter, and let us be clear, there are millions of lawyers in the country, right? But these 600-person letter, the Prime Minister himself is supporting this, and the government is the greatest litigant before the court, and the elections are coming, then I think this is something to be concerned about.
Okay, there's a lot of different points in there, and I'll let Sautik add to that and then go back to Dr. Agarwal on the example or the reference that Karuna made about his exchange with the Chief Justice in court in the SBI electoral bonds matter. But Sautik, let's pick up 2 points here. The Prime Minister endorsing this letter, Karuna says that automatically makes it political in election season, even if the lawyers had not intended it to be such as Percival argues. But on the other hand, Dr. Agarwala's example that when lawyers start invoking the golden era of judges, they're also asserting or inflicting a kind of pressure to nudge the judgment in a different way. Both sides are actually making mirror image arguments about the other.
Barkha, I think there's a slight difference, and I want to clarify that. When a lawyer appears in a matter and is being candid enough to tell the court and says to the court that I'm sorry, and if your lordships may allow me to say this, and Mr. Sibal makes his comment, it is something made in an open court to a judge being bold enough and candid enough at the cost of your client. And the judge is candid enough to listen to that and let it fly. The judge, as Ms. Nandi said, has broad shoulders. The institution has broad shoulders. What is happening now is that the constitutional mandate of free speech in India is unfortunately not in sync with our culture of being accepting of free speech. If a criticism is made, suddenly the size of the chest, decreases, and with it goes the size of the shoulders. The court has always had parens patriae jurisdiction over our citizens. We don't need 600 lawyers to have parens patriae jurisdiction over the Supreme Court. The court can look after itself. I don't think efforts made just before the elections, in the aftermath of the electoral bonds case, by lawyers who have not disclosed their conflict of interest in terms of how many clients they have who are affected by the electoral bonds case, making such comments and saying that there has been a culture of capturing the Supreme Court of this country by a certain group of vested interests. It's actually not an attack on those lawyers. It is a veiled attack on the institution and on our Chief Justice. The famous saying, "Kahin pe nigah hai, kahin pe nishana." This is what it is. They're telling the court, look, you have been catering to this for a long time. Now is not the time for you to maintain dignified silence. That is the real message of this letter, and it is extremely contemptuous. And as Ms. Nandi said, what is being highlighted is that 600 lawyers have signed this. There are about 15 lakh registered lawyers. So the real highlight is that 14,99,400 lawyers have not signed this. And that is the message that I think needs also to be sent across.
Okay, let's take a look at that last statistic, Percival Villamoria, that the majority of the legal fraternity, including yourself, have not signed this letter. And yet the letter, in a way, especially with the Prime Minister's endorsement, will now look like the voice of India's legal fraternity. Two, with the Prime Minister endorsing it, it becomes political. Three, the charge both Sautik and Karuna seem to be making is that the effect of this letter is exactly going to be what it's accusing the other side or the vested interest group of doing, putting pressure on judges.
Okay, so first of all, the one of the things is that I would not sign it if I was asked to, but it's not that I was asked to sign that. I don't believe that the 4,99,000 lawyers who are members of the bar were at all asked to sign it. It is just a question of a few like-minded people coming together to sign it. So I don't think that that is really an issue. Look, the point is that we are in an electoral season.
Mm-hmm.
My very short point is there will be different views and sentiments, and as lawyers, we have our own politics, but we should not be putting it out in the public. Okay. For example, anyone who knows me knows what my views are. But I mean, do I say it openly in public? No. Right. So, and also, look, even on the other side, the comment that was referred to by Mr. Agarwala, now made by a very distinguished lawyer. The point is this: at the end of the day, when you say that this is not going to be a golden era when the history of the court is written, uh, was that your sentiment when there was a decision a couple of weeks ago, which was where it went in your favor and in favor of the case that you argued? At the end of the day, this court especially, is extremely fair. It deals this issue properly on procedure, on merit. So, for example, if somebody comes and asks for a bail, Article 32, the court is right to push it back. And if such a comment is made in that context, then I think there is a reasonable ground for somebody to stand up and say that there is a political slant to that kind of a comment. Right?
So you believe Kapil Sibal's comments in court in the K. Kavita matter when he referenced the legacy of the bench were out of place or were pressure tactics?
I mean, if I was in his shoes, I would not make that, right? But I'm not. But would I then, go to town in public criticizing that? No, I don't think so, because that does even more damage. See, we've always, as a bar, had tradition of sorting out our differences as a legal fraternity. The legal fraternity has been very strong, and I think we should keep it that way, regardless of our political differences.
Dr. Agarwala, the other criticism of this letter has come from the political opposition that says that many of these lawyers some are members of the BJP, some are close to the BJP, and therefore this is now dividing the bar into the kind of fractured political camp that Mr. Bilamoria in the beginning said he did not want. How do you respond to that accusation? It's all over social media today. And how do you
I'm
see that charge?
I'm not, I have never been a member of any political party. Although
Mhm.
I have worked as additional advocate general of three states simultaneously, Tamil Nadu, Punjab, and Haryana. And before that, Mulayam Singh and Punjab, this Badal government. It is, we are not working on political line. When specifically a bar leader, he has been, Mr. Kapil Sibal has been the president of Supreme Court bar in 2002. He has been a law minister. And if he says like this, but problem in this country is because he think, because all the judges who are presently judges of Supreme Court who were promoted, who was coming from high courts, they were all appointed during Mr. Kapil Sibal's time when he was in government. He think they have been appointed through him. So whatever he will say, they are duty bound to do, and they are not doing. So that's why
You're
that
saying Mr.
golden
Sybil
era.
thinks he can, you're saying Mr. Sybil thinks he can control the judges of India?
This was the wrong impression he was having, and judges have rightly told him. You see, judges are being appointed on merit. Judges are deciding the cases on merit, not that Adish Agarwal is there, or ordinary lawyer is there, or Mr. Kapil Sibal is there. So today, judges, every time some law minister is there, and like in UPA government, judges appointments were being discussed, although Mr. Kapil Sibal was not a law minister all the time, but he was a necessary part in decision making. So
Okay.
likewise in NDA, Mr. Arun Jaitley used to be the in charge, even though he was not a law minister sometimes. So people think, oh, why when I appear, they have to do it. That is not the position.
Okay, let me bring in Karuna and Sautik now on, on this argument. Karuna, you said that the letter sets out to do exactly what it accuses the other side, the unnamed other side of doing. It also speaks about the allegation of bench fixing in very agitated terms and says that this is casting aspersions. In fact, Percival Villamoria just yesterday on this program linked what's happening with respect to the courts to the fact that countries like America can today wade into what India says is our internal matter. Why is America talking about rule of law? He said, we are implying that the rule of law is not in place, even though due process is very much in place. So how do you see or join the dots between these three events: the Kejriwal arrest, the comments by the United States and today the United Nations, and now this argument within the bar?
So a few things happened last week. There was the freezing of the Congress's bank accounts. This is the leading opposition party, possibly, in the country. There is the arrest of a sitting chief minister, and I think three other ministers of his government, possibly two of whom are still presently incarcerated. There has been the arrest of Hemant Soren, which hasn't, for some reason, provoked the same kind of outrage that Mr. Kejriwal's arrest has. And Mr. Soren was also a sitting chief minister. So that happened, of course, slightly earlier. Now, in such a situation, there will be, and with the elections coming, and there will be Article 32 petitions. There will be SLPs that come directly from trial court orders rather than first going through the steps. That will be coming to the Supreme Court because of time. Why is this time relevant? The time is relevant because the elections are coming. So in such a situation, I think we have to see this is where this open letter has been written. Also in a situation where the lead story in many, many media platforms is digging into the open now Pandora's box of the electoral bonds and linking what happened in that in those revelations with regard to government donations and timing that with particular actions of the ED, whether it was to prosecute or to refrain from prosecution. Mm-hmm. So therefore, if you take an outside observer, let's take the United Nations, right? What does it look like? When the Prime Minister speaks up today and says that the Supreme Court must be unbiased when the largest litigation before the court, which is the government, largest litigant before the court, which is the government, is taking actions in a democratic setup, which look perhaps problematic, then I think perhaps there's something to be concerned about.
But do you think the UN or the USA are in any place to make those comments? India wouldn't comment on what's happening with the Trump trial.
I see no reason that India shouldn't comment on what's happening, not with the Trump trial necessarily, but when there is
abortion rights,
Supreme Court, in Palestine, if Israel said that this is a domestic issue with regard to the bombing of the Palestinians, not, of course, to compare what is happening there, which is a genocide, with what is when you are particularly after the famine, with what is happening here. There's no comparison. But the principle, which is that we are an international committee, we all abide by certain deep principles, including the rule of law, and that's the idea. So whether those principles are being abided with, I think as an international committee, people should comment on each other.
I want to come to Sautik, but Percival, just a brief interjection, because you've been, at least on our program yesterday, you were very agitated. What does America mean by talking about the rule of law? This is the rule of law. This isn't it. This is what happens when there is a question mark over the courts, right? You heard what Karuna said. We live in a globalized world. People will comment. It looks to the outside world that the opposition is bearing the brunt of investigative agencies. The data also seems to bear that out. Indian Express did an excellent investigation on the disproportionate number of cases that the ED, CBI, and IT has registered against the political opposition. We have some of those numbers on our screen. We shouldn't be prickly when people outside look at this and comment. What do you say, Mr. Bilamori?
They can comment as much as they want. The difficulty that I have is exactly what you heard from Karuna just now. So, yes, so there was an Article 32, and Article 32, this is not the time, it may well be election time, but by and large, the Supreme Court will not entertain an Article 32. Will they do it for a common man?
Can you explain to our non-legal audience what is Article 32?
Article 32 is denial of fundamental rights.
Okay.
Right. So you are not making a bail application. You are going straight to the apex court and saying, Article 32, my fundamental rights are violated. And the court merely said, please go to the right forum. Even, let me just explain this a little more. Look, when the application was challenged in the Delhi High Court, the argument that was set forth, over there, and I thought it was a very ingenious argument. But what they really said is that, look, the grounds of arrest have already been given. So there is no need to issue notice. Normally, a court will always take your pleading on record and say, okay, I'm issuing notice to the other side to put forward its case. And they said that, look, the grounds of arrest are frozen. There is no longer any need. Let's just decide this matter here and now. And the court really said that, no, we have to follow the procedure. So the issue really that I have it is when we hear submissions such as this, where people who are non-lawyers, not involved in the matters, do not really appreciate, because what they see is some political party, and it is their job to campaign, right? A political party is their job to do politics. So they will say, oh, the court turned down the bail, the court did not hear me. So it is this narrative to which I objected to yesterday, and which I continue to object to, and which is why I sympathize with the sentiment expressed in the letter. Because that narrative is wrong. The courts in India have always been very fair. They look after the merits of the matter and follow the correct procedure.
So how do you explain though that the precedent in India is meant to be bail as norm, not exception, but bail seems to be increasingly the exception?
No, the point is, as I explained yesterday, Barkha, in PMLA there is under the normal law you can be arrested on a mere suspicion. That's been the law for a very long time.
Yes.
In PMLA, the yardstick itself is different. The arresting officer has to say that based on the documents in his possession, which is the RUD, the relied upon documents, he believes that there are grounds that the person is guilty. And it is against that yardstick that your bail application lies. And your bail application has a lower standard to meet. Because in the bail under Section 45 of PMLA, the standard is reasonable grounds to believe that you are not guilty. So if you are arguing the bail on merit, on facts which are yet to be proven, then you will hit a roadblock. But if you are arguing that bail in terms of the grounds of arrest, then you do not hit a roadblock. In fact, it is a lower standard. Now, the difficulty has always been that the ED has not typically furnished the grounds of arrest. That's a procedural issue, and the courts have stepped in. See, the Supreme Court has stepped in two cases which
Okay.
I mentioned yesterday and said that you must give the grounds of arrest.
Yeah.
Right? So the
Let me bring in Sautik and then we'll take a round of last comments. Sautik, earlier in the day I was speaking with a BJP member who's also a lawyer who is a signatory to this petition, Hitesh Jain. And he said that in the context of the Arvind Kejriwal arrest, his counsels bungled and now they're blaming the institution through proxies. I'm just giving you sort of the verbatim allegations. He also objected strenuously to individual judges like Justice Bela Trivedi, whom he said had been victims of what he called a smear campaign. He said this is what triggered the letter that individual judges, Justice Sanjeev Khanna was asked to reflect on his legacy, Justice Bela Trivedi has been subjected to a smear campaign. This, according to him, was also one of the triggers for this letter. And he said the lawyers can't bungle and then blame the institution. And he also pointed out that the same courts that are under attack today also threw out a PIL that asked for Kejriwal to resign as chief minister because he's in jail. How do you respond to some of these points, Sautik?
Two things, Barkha. Firstly, it would not be appropriate for me to comment on whether the lawyers bungled or not. And as far as the issue of Mr. Kejriwal appearing and arguing for himself in the matter is concerned, I don't think we need to mince our words as much to say that this is a legal case and a legal proceeding. I think the whole country knows that this is very much at least a politico-legal case, if not a completely political case. And I think it's a strategic call that Mr. Kejriwal has made, that he will fight politics through politics. And I don't want to comment on that strategy any further. But coming to the issue of a smear campaign against a particular judge because of the roster that the judge is assigned, or that certain cases are being assigned to that judge, I have a lot less experience than the other panelists simply because of my age. But from what I have read, surely this is not the first time that certain judges are facing so-called smear campaigns. The way to understand this is to see historically how have judges dealt with it. And the answer is that judges have always dealt with it through their judgments. And nobody else has had to come to defend them. If the issue of pressurizing a judge by making comments is concerned, in the last 1 year, you will have also reported in the Bilkis matter, where the Solicitor General made certain comments, the additional Solicitor General made certain comments, and the sitting judge had to say, look, it is very clear you don't want me to hear this case. And the matter was then put over post the retirement of that judge. So are judges being pressurized by lawyers? Yes. By senior lawyers? Yes. Do judges know how to deal with it? Also, yes. The issue is, where is the occasion for anybody to step in and say, I now need to protect this institution and I need to tell the judges that you should not be silent and you need to speak? What is it that this letter calls for? After saying everything it has to say, it in the end goes on to say that we are asking you as judges not to maintain a dignified silence. This is not the time for that. That is the meat of this letter, and that's what the change that it is calling for. And I see this as part of a series of attempts made since the electoral bonds judgment to try and control the discourse around political cases in courts. Should political cases come to court? Ideally, not as much as it has recently, but perhaps inevitably it has had to, because the democratic checks and balances have failed in the political sphere, which is why people have moved courts, starting from the Maharashtra elections, the changing of MLAs from one party to the other, the action of the speakers, everything has had to come to the Supreme Court. The Delhi LG and Chief Minister, now Chief Minister in jail, they are always in court. They are perhaps more in court than any other matrimonial dispute that we deal with. So the fact of the matter is these issues are being taken to court and judges will, with their broad shoulders, deal with it. Nobody else needs to come in and make it an issue of reputation. With regard to the international comments, is the US commenting? Is there an occasion for them to talk about this? The argument really lies in yes or no, whether you believe that we are a globalized world and the issues of every country, fairness in their elections needs to be commented or not. Why does it bother us if somebody comments is the real question? And that's the last comment I want to make, which is what I started with. That the culture of being accepting towards free speech and criticism is what we need to foster. Judges will do it through their institutional protections. I think lawyers need to do it just by being broad-shouldered to understand that in public positions and in public places, you are open to scrutiny, rightly or wrongly. And the answer to that is not to stop public discourse.
Okay, Dr. Agarwala, this is not the first time that there has been a focus on the roster in the Supreme Court. The last time the roster became an issue, the criticism or the questions were not led by lawyers, but by a section of judges themselves. There was the famous judges' press conference. I'm sure you would remember that. So this is not always taken the political opposition or vested interests. Sometimes these questions have been raised from within the judiciary. So I think it's also important to acknowledge that. To the larger points being made, that there are certain cases that are politico-legal, that you can't divorce electoral bonds, let's say, from Kejriwal's arrest. That's the AAP argument. They point to an accused turned approver, Aurobindo Pharma, that has purchased the maximum number of bonds for the BJP, 50 crores of which was done after the gentleman, the promoter of the company, turns promoter. How, therefore, do you separate all these issues that the letter
We have
talks about? Yes, go ahead.
we have to understand that Chief Justice of India is the master of roster regarding Supreme Court cases. And why he has been? Because he knows what judge can deliver the best judgment in which side of the cases. Different cases, different types, custom cases are there, income tax are there, rent control is there, land acquisition is there. Every judge can't be a good judge in every type of cases. So Chief Justice knows who can be the best in what type of cases. So he issue the roster knowing the background, the experience of the judges. It is if he is doing one case to specific one case now, PMLA, all these cases are going to specific bench because they are that has been assigned to that bench, that type of cases. These lawyers, when they are unable to get any favorable order from that bench, they say why it is being sent to that they are practicing in Supreme Court. They don't know that there is a roster. This has been decided by the Constitution Bench that the Chief Justice is the master of the roster. In High Court also, the Chief Justice of High Court is in charge. In District Court, District Judge is the in charge. What type of case is to be assigned to which additional session judge or additional district judge. These people, because they have never practiced, they whatever is being briefed, they just argue
What is the
without
aim of
having
the
any
letter?
foundation.
What for you as a signatory to the letter and the president of the Supreme Court Bar Association? What for you is the central aim of this letter written by 600 lawyers?
We wanted to inform that judges, these elements are trying to defame these people.
But
Elements
did
are
you feel
trying
the judges
to
needed your support? Did you feel that the judges
no,
were
not
not
required, not required.
strong enough
We
to
no,
handle the scrutiny?
this is not support. We are telling them these people are trying, and we are happy that they have not come under their pressure. Because these people, once they are out of power, they become frustrated. They charge so huge amount of fees from their clients by saying we will get the order. How much they are charging, you can't believe. So these judges are good enough. They know what is the law. And they have
Okay.
taught them a good lesson by telling them we will not come under your direction. We will not obey what you want.
Okay.
Whatever is possible, we will do.
Okay, Karuna, is there a problem of confirmation bias? This sometimes happens with the media, right? The day I do a story that somebody agrees with, they'll say you're a fair journalist. The day that I have praised for somebody they don't like, they'll say what a bias sellout you are. We go through this. We go through this every day. And it's an ongoing debate, what is objectivity, what is neutrality, is there such a thing, etc., etc. Is there a problem with confirmation bias? The argument that the letter makes is when the judgment goes your way, I don't mean you, but your way, whoever this other side is, then the courts are great. On electoral bonds, the courts are great. On Manish Sisodia, the courts are compromised. That this cherry picking is a form of pressure. That's the essence of the letter. What do you say? Sorry, Dr. Agarwal, are you trying to interject? Let me just unmute Dr. Agarwal, please. Yes, what are you trying to say, Dr. Agarwal?
You are asking me.
I was asking this question to Karuna, but I saw you speaking, so I thought you had an interjection.
No, you can continue. My
Okay.
sister
All
can.
right. All right. Karuna, please.
Thank you, Mr. Agarwal. Also, one request, Barkha, also in the spirit of this program, is that if we can all be referred to in the same way, maybe
Yes,
as
yes,
Dr.
yes.
Agarwal.
That is my mistake for having just known some of you as contemporaries,
Of
but I
course,
should be
of course,
mindful of that.
of
No
course.
other
That's a
disrespect
private,
is intended. No
relationship,
other
but
disrespect is
on a
intended. But go
forum
ahead.
like this,
Yes, fair enough.
thank you.
Yes, Miss Nandi,
Um,
do go ahead. Yes.
Thank you, Mithak. Now, here's the thing. Politicians come and go. Governments, ideally, politicians come and go, right? This is not something we can take for granted in today's world. If you look at Putin, for example, if you look at many other jurisdictions in the world, um, the court does not come and go. The court remains. Justice must remain. Justice, the processes of justice must remain unbiased, robust, the same, predictable. So when we had those 4 judges, speaking of the method of bench allocation and the fact that an individual cannot, based on them decide. I'm not saying that all of discretion should go in judicial decision making. It cannot and it must not. However, with regard to things like bench allocation, there is no reason that you can't have benches. For example, in the Delhi High Court, you have a bench hearing writ petitions for a particular time, a particular type of writ petition for a particular period. Right? So there's a predictability there. I think the objection to what was happening in the Supreme Court and what to some extent is still happening is that you don't know where the case is going to go, and there's no predictability with regard to that. And I think that what's very important is that when you have the Chief Justice saying very recently in the electoral bonds case, right, don't tell me what to do, don't tell me that I'm speaking from a place that is not constitutional, not speaking, don't keep telling me that X is the matter for the legislature to decide, thereby undermining my jurisdiction. We understand that the Chief Justice and the Supreme Court of India, the very existence of the Supreme Court, is to some extent not under threat, but being sought to be controlled, right, by a variety of actions, but including statements from the vast social media cell of the BJP, from the horrible pictures of the Chief Justice that are put up, making him just really like with I don't want to go into it, but they're all there online, making all sorts of horrible aspersions against him. And all of this must stop. And the Prime Minister cannot suddenly call on the Supreme Court to be not falling under pressure of those who are seeking him to be politically motivated, because what does that imply? It's not correct. Okay. And what we seek is predictability, and all of this essentially I think should be ignored.
Let me give Percival Villamoria the last word. In the American, I'm not a lawyer, but my understanding is that precedent has a much greater say, let's say, in the American legal system than in India, where it is true that individual judges intend to interpret the same case quite differently. To discuss that, does that amount to accusing the courts of bench fixing? We're not as bound by precedent, are we, as, let's say, the American system? That's question one. And question two, I think the point that is being made, and we will have to close after that, is that in election season, with the Prime Minister personally wading into this creates a multiple new layers of pressure on the courts, therefore leading to the opposite intent of what the letter said it set out to do.
Barkha, in the USA, it's very clear that you are marked as either a Democrat judge or a Republican judge, depending on which Congress was in power when you were put on the bench. So I think that's a very sad system, and I hope we never come to that, which goes back to my initial point that we do not want either our judiciary or the bar to be fragmented. So look, it's election time. there will be frayed tempers. We are a very noisy democracy. I want to take you back to 2019, all right, when there was Pulwama. There were people who had the gumption to say that, oh, it was the prime minister who was responsible for that. I mean, to suggest that the prime minister tapped the Pakistanis on the shoulder and said, hey, can you please do something so that I can teach you guys a lesson and I'll win the election? Right? That isn't that absurd? It's in the realm of the absurd. Now, this time we have a situation where there is a sitting chief minister who is incarcerated. It's a new phenomenon. It's never happened before. We all need to be very diligent and stick to the law. Now, I do not believe that the strategy that has been followed, Article 32, to go to a court and insist that, and again, I say it's a very ingenious argument, but to tell the High Court of Delhi to say that, okay, please decide it here and now. And the Delhi High Court says, no, but I have to follow procedure. So I do believe that, for example, Mr. Kejriwal arguing his case, he was not really arguing his case, it was political grandstanding. And I do object to the courts and the judicial system being used as political grandstanding. But would I put it in a letter that sparks a public debate? I don't think so. I think that's really the sum and substance.
Well, the debate has already been opened with no conclusive
Yeah,
final
so
word. The jury is still out, so to speak. Dr. Agarwal, I was going to say thank you, but did you have a closing thought? And I think, Karuna, you said in the chat that you might have one as well, and then I'll come to Sautik Banerjee, to Karuna Nandi, to Adish Agarwal, and to Percival Villamoria for a last round of quick comments in the spirit of equal time. So to Adish Agarwal first. Go ahead, Adish.
I can safely say it was not necessary for ED to arrest Mr. Kejriwal during this period because he is a chief minister. There is no bar, but he was not going to run away. And
So you
he
don't. So you
himself
don't
has a
agree with
right.
the arrest. So you don't agree with the arrest.
It was not necessary. During election time, when you waited for so many months, you could have waited during this time also. He's not. He's a chief minister. Politicians are here to rule,
Yeah.
not to run away from the country. So, and there was nothing wrong on his part to argue
Yeah.
his case in open court. And today, I thank for this corona when our prime minister given so much funds for courts to have virtual hearings. Everybody can argue from any place, and litigant is having his right. Mr. Kejriwal was having his right, and he raised not political issues. I'm sorry, brother. Eh, He pointed out on which ground he was arrested. Sorry, he has pointed out, but it was not necessary at this time when
Interesting.
election was there.
Well, I think, I think Adish Agarwal, for those who are branding you as a BJP affiliated person, your comments are
No, no,
extremely
no. I'm not BJP. I
significant.
told
I
you,
am not.
I'm not.
I am not. I am not saying it. I'm saying there are
The
a lot of
people
people
are
who have
fool
said
who
it.
are branding me.
Okay.
I am not on any panel of government of India. Although earlier,
Okay.
earlier
Yes.
BJP government of Punjab, I was additional advocate
Okay.
simultaneously of Congress
Okay.
government of Haryana.
Okay.
And the
Okay.
Karuna Nidhi, the same time, I'm non-political till now, never member of
Got
any
it. Got it.
political
No, I
party.
was just making the point that you made a significant comment. I'll move on from Adish Agarwal to Sautik Banerjee. Sautik, please go ahead.
Yeah, I just want to say that the issue of grandstanding during court proceedings, unfortunately, is not a one-way route. And we've had charge sheets leaked to news channels. You know that better than any of us, Barkha. You must have been on the receiving end of some of them in your career. So very often, portions of charge sheets, which are just allegations, are flashed across screens, and political and private lives are destroyed. So
Yeah.
grandstanding is very much, unfortunately, part of our legal system. And for once, if someone on the defense side has used it to whatever little advantage or disadvantage, we don't know. The jury is out on that. I don't think we need to make an issue of that. The central issue for me remains that we need to just be more open to dialogue, discourse, criticism, good or bad. And we don't need people to step in to protect our courts. The courts can look after themselves.
Thank you, Sautik Banerjee. Karuna Nandi, last thoughts?
Ours is a polyvocal court, unlike in the US, which sits in plenary. All the 9 judges in the US sit together. They sit very few times each year. Our court has a very wide jurisdiction, the widest in the world, the Supreme Court. So therefore, any order from any court, in theory, can go up to the Supreme Court under Article 136. What does this mean? That in the case of Arnav Ranjan Goswami, in 2020, when he is arrested, and he goes under Article 32, and the Chief Justice says that a single day of behind bars without bail for no good reason, right, is not to be countenanced, then that is something that we need to apply across the board. I think that these are very, very difficult times for the court. Very difficult times. And as lawyers, we must stand together to protect the court, its processes, with due criticism. I'm not saying that, lawyers should be silent, but I am saying that this is a very difficult time for the court. And as lawyers and jurists and citizens, we all must stand strong for due process, rule of law.
Thank you, Karuna Nandi. Percy Bilemoria, last word to you.
I think in the case of Arnav Goswami, it was an Article 32, but there it was also about the freedom of the press, which is why, I do believe it was taken up at that time as an extraordinary case. Now, the point I really want to ask is, see, the thing is that the skeptic in me says that the first summons was issued in November 2023. That was not answered. 8 summons were not answered. I do believe that there was a political strategy behind this. And, at some point we have to also understand that non-answering of a summons is an independent issue altogether, for which there can be a summary trial. So therefore, let's just agree to disagree on some of the things, because look, I don't think that any profession can claim to be immune from the law. You may be a politician, but you cannot be immune from the law. You may be a lawyer, you may be an activist, a journalist, but you cannot be immune from the law. So therefore, I don't find anything wrong with his arrest. The question is, as lawyers, we should be asking ourselves, what is the evidence? Instead of just saying, sitting chief minister is arrested, please ask yourself, what is the evidence before sitting on judgment as to whether it is right or wrong. He will be proved right or wrong, and that is up to the courts to decide.
We'll have to leave it there. Certainly enjoyed this layered, textured conversation. Thank you so much to Adish Agarwala, Karuna Nandi, Sautik Banerjee, and Percy Bilemoria, and to our audience. Thank you for watching. Have a great weekend. Mojo Story has always made a commitment to its viewers to go to where the story is. And as you can see here, we are at the epicenter of the Israel war on Gaza. We are right at the front line, about 1 mile from the Gaza Strip, as the Israeli military gets ready with its tanks and its gunners to begin its final frontal assault that will take troops into Gaza. As we said, we are not like other organizations. We believe in giving you all sides of the story objectively and as much as possible from the ground. And that's exactly what we're doing here, covering the biggest global story today from the epicenter of the war zone. So please, we need your support. Support us, become a Mojo member, subscribe to us, spread the word, and thank you for your support.